It's December 23rd, 2025, and this is the court gallery. Welcome, ladies and gentlemen. Today, we'll be starting off with Judge Crum and the sentencing of a woman with a staggering 45 prior convictions. Her defense attorney will make one of those most passionate arguments for sobriety. For a second chance, you just won't believe it. The prosecution has a very different take. The question has to be asked, is this woman someone who's finally hit rock bottom? Or is she a public safety menace who has simply run out of time? Then, ladies and gentlemen, we'll see a custody battle presided over by Judge Ricke, where mom shows up late to the custody hearing and is in a mood and makes one of the most serious and shocking accusations a person can make against a father. And she does it right to Judge Ricke's face in defiance of his court orders. You can guess how that went. Going from Kansas crazy to Michigan madness, ladies and gentlemen, Judge Dad hears from a defendant who claims he's been hunted by the federal government for breaking the code, forcing the judge to navigate a story of sabotage and conspiracy while trying to just address a simple bond violation. But that guy's got nothing on the king of the world, whose vile texts visibly anger Judge McNally as they read into the record. Well, as they're read into the record. You know what I'm trying to say. You're not gonna like it. It's crazy, and it all starts right now.
All right, let's go on the record. This is in the District Court of Butler County, Kansas. Case is entitled...
Greenwood.
Did I say Butler?
Uh-huh.
All right, well, this is in the District Court of Greenwood County, Kansas. Case is entitled State of Kansas versus Bailey Cartile, case number 24 CR 61. Would counsel announce appearances, please?
May it please the court, the state appears by Joe Gillette, County Attorney.
Your Honor, Mr. De Hoyo is here on behalf of Ms. Cartile, who also appears by Zoom in from the Greenwood County Jail.
All right, we are scheduled for sentencing today. Ms. Cartile entered a plea to a number of different charges back on January 2nd. There were some holdups in getting court records from other jurisdictions, perhaps a failure to appear, but I do have a PSI, and are the parties ready to proceed to sentencing today, Ms. Gillette?
State is, Your Honor.
And Mr. Hoyos?
Yes, sir.
All right. The PSI that I've received indicates a criminal history score of A. Ms. Gillette, any objection to the criminal history score?
No, Your Honor.
And Mr. De Hoyos?
Judge, two things. One, no objection. I've done my research on this and I think it is accurate. Can we take the Greenwood County Jail off of mute so that my client can participate? Thank you.
All right. So there's no objection from the defense to the criminal history score of A?
No, Judge.
All right. Ms. Gillette, are you aware of any legal reason why we should not proceed to sentencing today?
No, Your Honor.
And Mr. De Hoyos, are you?
No, Judge.
All right, I did receive, and I've had an opportunity to review a motion for dispositional departure filed on behalf of the defense. I'd like to take that up First, Mr. De Hoyos, if you could make argument in your sentencing recommendations at this time.
So, Judge, two things here, or a few things here, rather. The motion is not just for a dispositional departure. In the event that you cannot find good reason to put somebody on probation in this matter, we're asking you to consider a durational departure down to 17 months incarceration. That reflects half of what we expected was going to be a B box sentencing. It came out as A box. Judge, I'm going to stress that when you go back through her criminal history, through Ms. Cargile's criminal history, I mean, you see that she was battling addiction. There's no question about that. And Ms. Cargile will tell you the same. She recently returned from Washington, having done something like 6 or 7 months incarceration there. Was brought here on a governor's warrant to answer for these matters. There was some confusion about when her original sentencing date was, and then when it was pushed back, when the next sentencing date was. And after talking with Ms. Cargile, she'll be able to expand more upon this. I don't think that she missed the court dates with any bad intention. I think that there was a significant miscommunication because of the way we had to bounce this thing around a couple times. All that being said, Judge, I'll tell you right now, I don't know anybody who said, I went to prison to get sober. That's not a thing I think happens. I think that people can find sobriety when they're ready for it. And in this time that we're here meeting today, Ms. Cargile has more than 7 months of sobriety. This is the most sober she's been, I think, in her adult life. While she has been incarcerated for a significant portion of that, my point is very simple, is that by imposing a probation sentence today, we have the foundation laid for her to be successful in recovery. She's still very young. She can still become a very well-accomplished adult, become an active member and a contributing member of society. I do have full faith and credit that when she is sober, she's the kind of person we want her to be. And I think that if this court gives her that opportunity, the kind of opportunity she has never received from any court in the United States, then she will demonstrate to you that with proper treatment and sobriety, she's awesome. She's great. Now, Judge, to that end, I've been working with Ms. Cargile since she got back in early December to set up treatment plans, to set up sober living environments, to set up more. She can expand upon that, but we have things arranged with Cornerstone. We have a drug and alcohol treatment evaluation lined up. Judge, I mean, Ms. Cargile is jumping through every hoop she can to demonstrate to you that she wants her life back in her hands, that she wants her life back in her hands, away from sobriety, or away from intoxication and back to sobriety. She's got a kid out there that she needs to go take care of. And ultimately, long-term, Judge, I don't think that the taxpayers of Greenwood County or the state of Kansas are made better by Ms. Cargile's incarceration. I think they're made better by a treatment plan, by Ms. Cargile going through the proper steps and embracing sobriety full-fledged. I think that she's bouncing off rock bottom right now, and we can either stunt that by throwing a rock against her and tying it to her ankle and throwing her in prison, or we can support that by giving her a shot on probation to demonstrate that she is who she says she is and that she is becoming a woman that we want to have in our community. So for all these reasons, Judge, and again, I'm going to ask Ms. Cargile to expand upon it when you ask to speak to her. For all these reasons, I don't believe our society is better off with Ms. Cargile in prison. I don't. I think that she needs an opportunity of probation, the kind of opportunity she's never received from a court, and giving her that good grace one time might very well make all the difference for who she becomes.
All right. Thank you, Mr. De Hoyos. Ms. Gillette, if you could respond to the departure request and provide your recommendations.
Your Honor, Ms. Cargile is presumptive prison. Ms. Cargile has earned her criminal history. She's 34 years old and she's had 45 convictions. This case was committed while on felony bond out of Skagit County, Washington. She's gone back and forth between Washington and Kansas. She had a failure to appear, was not meaningfully participating for her pre-sentence investigation. We brought her back on a governor's warrant. She finally signed her extradition on the 13th of November. The governor's warrant was obtained on November 9th. She had to be brought back. There is a transport cost. We're going to be asking for restitution of $4,108.77 to have her transported back from the state of Washington. This case, as I said, was committed while on felony bond. That's one of the cases she was arrested for out there while she was in Washington.
Miss Gillette, I don't see a special rule marked indicating she was on.
If
Felon.
you look at the original PSI that was filed April 16th, 2025, or it was submitted April 16th, 2025, it is marked there. Crime committed while on felony bond, Skagit County, Washington, 23-1-0037229. That
So
case,
what, I'm looking at a PSI I received, I believe earlier this week.
yes, they changed it from the one that was submitted in April to the one that was submitted in December. That special rule was not put on the new one, but it was on the original one.
Well, is it supposed to be in effect?
It should be in effect.
Judge, if I may here,
Go ahead.
two things. As I understand it, and Ms. Cargill, I have to make sure I got this straight. I think that the case that she was on bond for was ultimately dismissed. But more than that, Judge, by law, I do think it would be accurate that special rule would be marked. That's just an operation of law as opposed to the merits because the case was dismissed.
Yes, Your Honor.
All right. Ms. Terrones, are you here from court services?
I am, Your Honor, and that is correct. Christine said she took it off because that case was dismissed.
All right. So it has no functional application because there'd be nothing to run it consecutive to.
Correct.
I understand that. Okay. Go ahead, Ms. Gillette.
In addition to that, Miss Cargile might have been battling addiction, but her criminal history shows a history of violence. She had, starting in 2011, battery against a law enforcement officer, interference with a law enforcement officer, another battery in 2021. That was her conviction date. That was a 2012 case. As you go on through, number 16 is battery of a law enforcement officer. As you move on down, she has endangering a child. She has assault and battery with a dangerous weapon, driving under the influence of drugs, resisting an officer, leaving the scene of a collision involving damage, obstructing for an officer. She has reckless driving. She has driving under the influence several times, simple assault, which were her most recent convictions while she was out at Whatcom County, Washington, where she had last been housed before being brought back to Kansas. Her current crimes of conviction is possession of methamphetamine, felony fleeing an officer, battery against a law enforcement officer, driving under the influence, and reckless driving. These all are serious things that cause she fled in a vehicle from an officer. She's a public safety risk, not once, but twice on her convictions. She puts the entire population at risk when she is running from officers. Not only that, but she actually harmed an officer in this case by causing a car accident where she slammed on her brakes and made the officer hit the vehicle that she was in. And not only did she flee, she ended up going onto roads down into all the way into other counties. She has caused all kinds of mayhem and problems through multiple states. And we had to go get her. And so I do not believe that Miss Cargile has earned the right to be among the general population. I believe that she warrants going to prison. This is not a case where the state is in agreement. I actually considered filing a motion for an aggravated sentence. I did not, mostly because I talked to Mr. De Hoyos. The state is going to be recommending the standard term of 40 months for Ms. Cartile. We are going to be recommending the up to 20% good time credit on count 1. 12 months post-release. She has jail credit that needs to be awarded to her of, I believe, 99 days.
Ladies and gentlemen, this is your obligatory call-in pause. Welcome, call-in crew. What you've been missing out on is we have a lady here who swears that she's going to do better this time. She's only messed up about 45 times before now, and Jill is painting out a pretty clear picture of why this time she just needs to go to jail. And now, back to the program.
No contact with her co-defendant. Her sentencing has had to be moved numerous times due to her failure to appear and us having to drag her back from Washington County. Fleeing an attempt to elude a law enforcement officer, we are recommending the standard 6 months, up to 20% good time credit, and 12 months post-release. Battery against a law enforcement officer, we are recommending the 12-month sentence. Driving under the influence, 6 months, and the reckless driving. It is an unclassified misdemeanor. It has a range of 5 to 90 days based on the statute. We are recommending the 90 days. I will recommend that they be concurrent. I considered asking for consecutive based on her criminal history and behavior. But I will recommend them to run concurrent. She has court cost of $193, a $400 KBI lab fee. She's already on file with the state of Kansas, so there's no DNA fee. We are recommending her $45 booking and fingerprint fee and restitution to the citizens of Greenwood County for $4,108.77 for her transport cost for bringing her back here. It is her choice to take advantage of the programs that we have here in the state of Kansas at KDOC. Those programs that she can take advantage of would give her program credit. But the state is not recommending any kind of departure for Ms. Cartile.
All right, thank you, Ms. Gillette. Mr. De Hoyos, anything else as far as sentencing recommendations?
2 things, Judge. Briefly, she can't pay back the people of Greenwood County if she's incarcerated. $5 an hour is what they pay in prison, and Lord help me, I don't know how many hours it is, but it would be, she doesn't sleep a moment she works at all. But also, we're talking about somebody who's here by criminal history A on converted misdemeanors. She is not a true criminal history A. She is here by way of converted misdemeanors. So I don't think I have to go about telling you how many terrible people I've represented in my career, but this isn't one of them. It really isn't, Judge. I think she needs a chance at sobriety. Keep in mind, she was incarcerated for like 6 or 7 months before now. She's not going to get credit for it because the case in Washington was dismissed. So if you're looking for somebody to have a sober foundation and a future that you might be able to witness with probation, Ms. Cartile is the right candidate.
So she's never had an opportunity to complete treatment during the course of any of these cases?
So, Judge, I think it's saying too much to say that she never had the opportunity to complete treatment. I mean, she could have always sought treatment if she had come to that term herself, right? But the court has never ordered her into treatment in any of these cases.
All right. Thank you, Mr. De Hoyos. Ms. Cargile, is there anything that you would like to say before the court pronounces sentence?
Your Honor, I have struggled with addiction for more than all my adult life. I know I have made several bad decisions and that I was wrong for that. The day that I caught this case, we've been on the road for 3 days. We were headed to my father's funeral. When I got stopped, I know I should have handled it differently. I wish with everything I am that I would have. But just like the fear of missing his funeral and just the drugs and just everything, I just panicked. Over the last year and a half since I got out on bond, I did everything I could to make every single court date and comply with every request from the court. I know that my last court date, I did miss it. Your Honor, when you guys were going back and forth about the court date, I promise you, I wrote down the wrong date. I wasn't going to be present in Greenwood, but I was going to appear on Zoom. When I realized that I missed it, I did reach out to my lawyer. I did turn myself in to Washington to address my issues. The only reason I requested a governor's warrant is just because I was advised by my lawyer to address those issues in Washington prior to coming here, just so it would be done. Those cases was like 3 years old. Since I have caught this case, I have not caught any other case. And I have addressed all my cases that I had before that, and got them all resolved. But due to me having a hold out of the state of Kansas, they didn't offer me any rehabilitation out of the state of Washington because of this case. And several years ago when I got in trouble, that was the same case. I had a hold out of a different place. So every time I've been in trouble, that's why it just like last minute they made a deal and I wasn't able to receive rehabilitation ever. And I think that that would be life-changing at this point. I have did a lot of things to turn my life around and like leave bad habits behind. I just think that if I could receive some help like with rehabilitation and get some skills to help me be successful in the world without, you know, when I go to prison, I get out and I feel more separated from everybody and different, and I don't have anything to stand on. And I want to be able to do something different. At this point, the only thing I fear is failing again. So I apologize to the court for missing my last sentencing, but before that, it was only put on hold because the DA asked for more time. But I do apologize for my part in missing my last one. And I hope the court will forgive me. And that's it. Thank you.
All right. Thank you, Ms. Cargile. Counsel, what is the minimum statutory fine on a Class B DUI? Is that still
$750, Your Honor.
all right, Ms. Cargile, for the primary offense of possession of methamphetamine, a level 5 drug felony with your criminal history score of A, I do sentence you to the standard mid-range term of 40 months with the Kansas Department of Corrections. You are eligible for 20% good time credit and are subject to 12 months post-release supervision. In count 2, for the offense of fleeing or attempting to elude a law enforcement officer, a level 9 person felony with criminal history score I do sentence you to the standard term of 6 months with the Department of Corrections. You are eligible for 20% good time credit, subject to 12 months post-release supervision. For the offense of battery against a law enforcement officer, a Class A misdemeanor, I do sentence you to 12 months in the Greenwood County Jail. For the offense of driving under the influence in count 7, a Class B Non-person misdemeanor, I do sentence you to 6 months in the county jail and impose a $750 fine. For the offense of reckless driving in count 11, an unclassified misdemeanor, I do sentence you to 90 days in the Greenwood County Jail. The court has reviewed the motion for dispositional and durational departure and has listened to the arguments of counsel. I will note there is a special rule that applies that this is a third or subsequent felony drug possession and your criminal history, criminal history score A, based on your prior criminal history. Ms. Cargile, going through this, you have 45 convictions. Starting back in 2005, yes, many of these are misdemeanors. There's your standard traffic, driving while suspended, MIPs, battery of law enforcement officer, interference with law enforcement officer, theft, battery, possession of drugs, theft, endangering a child, theft, assault and battery with a dangerous weapon, DUI, resisting arrest, leaving the scene of an accident, possession of forged notes and instruments, obstructing officer, criminal mischief with a deadly weapon, theft, simple assault. I find it hard to believe that during the course of all of those cases, especially the drug cases, that a court never ordered that you be evaluated and complete treatment. I suppose it's possible. However, you're almost 35 years old. You continue to commit crimes. At some point, somebody who was interested in getting sober and getting their life together, having children to support, would take that initiative themselves rather than continue to commit crime after crime after crime. This one, fleeing or attempting to elude a chase through Greenwood County, battery of a law enforcement officer while under the influence, getting out and running from the car, having to have drones or whatever they had to try to find you. You're a risk to the public, Miss Cargile. And I'm sorry if you have a substance abuse problem, but you don't seem like a person who's taken any steps to meaningfully address that, and you continue to commit crimes. You're a poster child for a criminal history score A presumptive prison case, whether they're all felonies or converted misdemeanors, it all adds up. And I'm not finding substantial and compelling reasons, so I am going to order or deny the request and follow the presumption of prison and place you in prison for 40 months. For count 2, you do have some jail credit of 99 days you'll have against that 40 months. I'll run the remaining counts concurrent with one another, so you'll have 40 months minus time served on this case. I'm going to order you pay the court costs in the case. Going to order you pay a $400 KBI lab fee for the testing of the drugs. I'm going to order you pay a $45 DNA fee, or booking fee rather. I'm going to order that you pay restitution for $4,108.77 for the costs of Greenwood County having to retrieve you from the state of Washington. pursuant to State versus Robinson. And your period of incarceration and future incarceration, I will waive bids, application fee, and bids, attorney's fees. You may have a right to expunge some or all of these convictions at some point in the future after your sentence is completed and a couple of years have passed. You might look into that. You do have a right to appeal this sentence. If you choose to appeal, you have 14 days from today's date. If you can't afford to hire an attorney, one will be appointed for you. As a convicted felon, you can't possess firearms, and there are the loss of certain civil rights, such as the right to vote, until your sentence has been fully discharged. In case I didn't make it clear earlier, you do have 20% good time, eligible for 20% good time credit, and are subject to 12 months post-release supervision. Ms. Gillette, are there any sentencing related orders that you feel I failed to address?
Did you mention prohibition of firearm?
I did.
Okay. Remand to the sheriff for transportation, so I'll bring all left.
Mr. De Hoyos, can you think of any sentencing related issues the court's failed to address?
Judge, the only concern I have really comes down to jail credit. I mean, if this case was pending during the time that she was held in Washington and you ran a concurrent to her Washington cases, there's an additional 6 or 7 months of incarceration credit she would receive, which otherwise I don't think goes anywhere because the case that she was being held on gets dismissed, or it was dismissed. So
That's true.
ultimately what we're talking about is giving her credit for the time she's been in custody.
She got credit for the Whatcom County, which was the last county she was in. Whatcom County is the last 2 convictions that had to be updated on the PSI, or last, maybe 3. She had to have updated on the PSI.
Any credit that she legally has coming, she should get. This is what's been listed in the PSI. That amount wasn't contested earlier, so this is what the court's ordered. If there's additional time that she should have credit for, it'll need to be brought before the court elsewhere, but that wasn't done, so that's what I'm ordering based on the information I have here in the PSI.
Judge, I guess it just begs the question, is this concurrent or consecutive to previous cases?
Well, there's no special rule requiring it to run consecutive to anything else. I haven't ordered it to run consecutive to other cases.
Thank you, Your Honor.
So, all right, Ms. Cargile, do you have a question?
Yes, Your Honor. So does that mean since I've been incarcerated since July 8th that I know that my case is out of Whatcom that I did handle on the paperwork there, it said would run concurrent to anything else. But after that, I was in Skagit County for like about the last 4 months. But I've been completely incarcerated since July 8th. So I will get credit for that.
I've given you credit for the days that are set forth in the PSI, which total 99 days. I don't know if that encompasses some of the dates you're referring to or not.
All right, I'll check with my lawyer and maybe call my other lawyer and see if I can get the exact dates and submit them to my lawyer, if that's okay.
All right, Ms. Cargile, I encourage you to take advantage of any treatment programs or other programs that may be available to you in the Department of Corrections if you do truly wish to be out and be a productive member of society.
Yes, Your Honor.
At this time, I'll direct that you remain in custody until transportation can be made arranged to take you to the Department of Corrections.
Thank you, Your Honor.
All right, if there's nothing further, we'll be in recess on the Bailey Cargile matter. Thank you.
Marriage of Jesse Lewis Nix and Amanda Nix, case number 2015 DM 507. Jesse Nix appears as movant and petitioning party in the case. Amanda Nix does not appear. I will note that a notice of hearing was sent out by this court's assistant back on December the 2nd. Does Amanda Jesse still live on North?
Okay. The last time that I seen the children, they said that they were moving. I have drove by the house a few times, and her boyfriend's car is still there. I'm guessing that she hasn't.
Okay. Well, she's got a duty to notify the court if she changes her address too. I think that's the last known address that we had on her.
Yeah.
Service was obtained at that address last time that there was a motion before the court earlier this year. All right, Jesse, what's going on that you need relief from the court?
I can't see my children. I can't call them on the phone. My oldest son has, in the last month or so, has stolen a pair of shoes from me. He stole a very expensive Xbox controller from his grandfather about a year ago. I just don't understand why I can't even call my children on the phone because I got a motorcycle accident.
Okay. Why is Amanda not allowing this? Do you know?
I have no idea.
Okay.
I have no idea.
You haven't talked to her about it?
She told me that. Sorry, say that again.
Okay, you're breaking up. Say that again.
Last I knew, well, for one, I can't even talk to him on the phone. Two, my oldest son is now completely lost respect for me. He's stealing now. He's using marijuana. I don't understand why I can't simply just call my children to tell them I love them or happy birthday on their birthday or Christmas, Merry Christmas on Christmas. This is all based on her wanting child support. She wants payment, and she's done all. This has all happened because of that.
Are you behind on child support?
Yes, on my other two children, yes, I'm about $1,000 behind. I'm paying, but I'm behind from the wreck.
Oh, okay. Okay. You're paying your current support though?
Yes.
Okay. Well, these are independent obligations. I mean, one doesn't necessarily cause the other not to take place. What are you seeking here today?
My children to come back and live with me. I know that it's a concern that they won't be going to the same schools because I live in Towanda, but that's not a problem. Never has been. I'll transport them myself.
Okay. So has Amanda reacted at all after receiving your motion, Jesse?
No. Says I can't even talk to them on the phone because she works every night and every weekend.
Who's watching the kids while she's working?
I have no idea.
She's entering the meeting right now, Judge.
All right, join with audio, please, Amanda Nix.
Yeah, I'm here. Sorry, sir.
We're now 9 minutes past our scheduled start time. Amanda, why weren't you on at 10 o'clock?
Because I had Zoom on my phone, but it offloaded, so I had to re-downloaded it, and I didn't know I needed to re-download it. And I just got it downloaded and signed in. I'm so sorry.
The ground that we've covered, Jesse says he's not getting any rights with his kids, that you've cut off phone contact, personal contact. Is that true? Okay, you muted yourself.
Your Honor, I have cut off contact under the only circumstances that he is under investigation right now for an incident with one of his children. And I am not comfortable sending my children with him with what he is being investigated for at the moment. Like,
Correct.
Well, you're going to have to
I
give
don't
me
know.
more than that.
Okay, he has two older children, one of them being 16, one of them being 21, and the 16-year-old has come to her mother and told her about incidents when she was littler of her father touching her inappropriately and doing inappropriate things to her. And there is an open investigation right now over this. I had to take my children in to talk to a detective and to a specialist to see if they have been touched. And I'm not comfortable sending my children, especially my daughter, to him if these allegations are true. And I'm not saying they completely are at the moment, but I am not going to risk my children being in that situation due to I'm a mother, and no parent would want to send their children to a situation where something could happen like that. Like I don't know what else I'm supposed to do.
Court orders would be a start.
I've been waiting for the investigation. She said it would only take like a month or two, but I guess there is a new detective on the case. I just talked to Jesse's ex-wife, who is the mother of his other two children, and she said they put a new detective on the case and they are still investigating him, but there's some other things they need. And I know it's not a closed investigation at the moment, or he hasn't been prosecuted, but no parent in their right mind would send their children somewhere where someone's being accused of these things, especially their own father.
When allegedly did these things that are being investigated happen?
His daughter is 16, and she has not had contact with him in like 4 years, which she just felt comfortable enough knowing she don't have to see him again to come to her mother and tell her these things. But she said it was happening to her from like the age of 6 or 7 all the way up till she was 11. And this is his blood daughter. Like, this is his daughter.
Your Honor, the detective's name is Sarah McKee, and she said she's more than willing to help me in any way she can. So I'm sure that if somebody wants to talk to her about the case, and they can call her.
Okay, well, that case isn't currently before this court. What this is a domestic action, a family law action in which court orders have been made to allow the constitutional right of the father to parent to actually take place. And Amanda, it seems like you throw up roadblocks every time the court establishes orders. Then you come up with something that supposedly and has not been confirmed happened to some other child, not of your relationship, to cut off all rights, not only with the daughter, but also with his sons.
I have not cut off contact with them. My sons have cell phones, and he has their phone numbers. He can call them at any given point in time. I did not block him from their phones. I did not, nothing. He is more than willing to call them, to get a hold of them, but he does not try to. I gave him the children every other weekend like I was supposed to until this incident occurred. And I don't know how anybody in their right mind could send their children off to somewhere where these are allegedly this has happened. Like, I don't know how that is okay in any parent's mind. Like, true or not true, if he is being accused of this by his own daughter, I do not feel comfortable sending my children there. That is not in their best interest to go with him, even on top of them not wanting to go already. Like, it just adds on to it, and I do not feel comfortable doing it. I cannot send my children to somewhere where they could be molested.
Well, this court has also had experience with false accusations that that never were proven to be the least bit meritorious.
I have
So I
not.
also know about that too. And you know, I think it's also significant that this is not a child of this relationship.
It is my children's sibling. It is his own blood. They are close to their sister. Not being my own child or not. If it was your child, would you send her? Like, no way. There's no way you would send your little girl to a man who is being accused of molesting his own daughter.
Okay. All right. And what about the boys?
Boys, or like, it's a child.
Oh, okay. All right. So because this accusation is made, you feel like you just have a unilateral right just to cut off all visitation contact.
As a mother, yes, I feel like
I do not agree,
duty.
Ms. Nix. I do
That
not
is my
agree.
duty as a mother to protect my children.
I do not agree.
It's not to protect my children.
You can protect your children, but there's not even any showing here that your children are at actual risk in any way. There's not even an accusation that he's even done anything to your children.
It doesn't matter if it's my children or not. He has touched
All right.
his daughter.
Well, we're not going to argue this out. There are existing court orders, and the court intends to enforce them. Ms. Nix, I've told you this before, and I'm going to tell you again. If you can't manage the role as a custodial parent, then Jesse can be their custodial parent, and we'll see how he works.
He can
with
molest
you.
his children. That's what you're going for here.
Is there any confirmation whatsoever that there's a credible claim that he has molested any of these three kids ever?
It doesn't matter what kids it is. If
Okay.
he molested a child in general,
Okay. All
that
right.
is not okay.
All right. I can see what
Are
you're
you condoning him doing this?
All right. Jesse, what are you seeking here as far as relief is concerned?
For my kids to come back home so I can,
You
again,
mean to be a custodial parent?
yes, I can again prove to them that I'm a good father again. Just because I got in a horrible motorcycle accident and I'm from Topeka doesn't mean I'm a bad father.
Well, I'm trying to determine from your attached parenting plan exactly what your parenting plan calls for.
For me to, one, be able to see my kids again. I haven't seen my three youngest in 2 months now. For just for them to understand that I am still the good father that I was before motorcycle wreck. There's no reason why they can't answer a phone call when I'm calling their phone, not their mother's phone. I don't know. I've done everything I can to be a good father. It is in me. I strive to be a good father. And I can't even talk to any of my children on the phone now because I got in a horrible motorcycle wreck.
Okay, so you're living where right now, Jesse?
Honda.
Okay. And the kids are in El Dorado?
Yes.
They're not very far apart. You're supposed to be meeting at the Quick Trip in El Dorado to exchange, correct?
Yes.
Well, there's no motion to even alter the current parenting plan, which I know calls for every other weekend visitation with all kids. Court specifically said in March that the kids must go. They don't get to unilaterally decide that they don't want to go. They're entitled to a relationship with their father, and the father is entitled to a relationship with them. There probably needs to be some sort of professional intervention in this situation. There needs to be some family therapy where everybody sits down and as a family, this gets sorted out. This is not the way things are supposed to work. I noticed the concern you have, Jesse, about Amanda using meth again.
Mm-hmm.
Amanda, could you pass a UA test right now? She seems to be non-responsive. So
I didn't hear you, Judge. If you said something, I'm sorry.
can you pass a UA for drugs right now?
Yes. I've been clean since before I got my children back, Your Honor. Like, I take care of 3 kids 24/7 all day, every day. It's not something I want to do by myself. I would love for them to have an active father, but he isn't active once you give him the part. I don't know how to prove it, but I could follow him around with a camera every time he has him. But he doesn't come to their games. He doesn't know about their practices. He doesn't show up to anything.
Do you tell him when these are?
Yes, and he has access to everything himself.
I'm sure, Your Honor.
He has came to 2 of football games that happened when he was still in football. But Jaxus and Pixie are both in wrestling now. And he wouldn't show up unless he had the kids. Like, he doesn't show up to support them unless he has them physically in his care. But he doesn't get involved in anything else. He doesn't ask about schooling. He doesn't call the school. He does nothing with the children. And when he has them, he sits in his bedroom at his home and doesn't even do anything with them. Like, they don't want to go with him. And I'm pretty sure my son is 15 and he is of age to speak for himself or have his opinion be heard. And if I would be able to do that, he would let you know how he feels exactly. Like, he puts on a good act. Yes, he does. And that's how he had me manipulated for 12 years. But I'm not saying this just because I want to be evil towards him, because I would love for him to be a great father and I would love for him to help with the children. But he has no financial responsibility towards them. I've asked him to help me pay for their sports, and he told me that he will never speak to me about money and he will never give me any money. And it's not giving me. I said he could write a check to the cheerleading organization, and he will not. He will not put any effort into helping me with these children. All he wants to do is take them from me to hurt me. Like, that's all it's ever been. I don't know what else to do here. I love my children with all my heart, and they do not want to be with him. I don't know how to show you this or what it is I need to do, but he is not a good father. He has never been a good father. He has 2 older children he doesn't even care to get a hold of. Why is that? Why doesn't he talk to them children? Because he has allegations against him towards these children, and he knows that, so he just keeps his distance.
Of course, my concern here is the children from your relationship.
Correct. If he's such a great father, though, why can't he be a father to his other children? He's just going after my children to hurt me. He knows my kids don't want to be with him. He made a whole bunch of accusations in his paperwork he turned in. But nothing he is saying is getting talked about because he just does it to get a court date. Nothing in that is true. It says he hasn't seen his kids since April of 2024, which he just said he's seen his kids 2 months ago. Like, I have not cut off contact with the kids getting a hold of him or him getting a hold of the kids. But that's only because I knew he wouldn't do it. Like, he doesn't try to.
First of all, Amanda, I'm going to order you to have your kids unblock their father from their phones.
I just said he's not blocked on their phones.
All right. I
Never
think he's
has
under
been.
the impression that he is.
He's blocked on my phone because he contacts me over and over and over and over, and I don't know what else to do. I don't want to argue with him and fight with him, so I block him. So there's no argument. Yeah, he wants to talk to his children. He can call his children.
Yeah,
he chooses
those are
not
great
to.
lines of communication when you block the father of the children from your phone.
Well, he has earned that place with me. I don't know what.
Jesse, can you call your kids directly?
No, I cannot.
Why?
She works every evening and every weekend.
Well, no, wait a minute. I'm asking you about calling your kids directly.
Yeah, I can't call RJ's phone.
Why?
I cannot call him from a man's phone. No,
That's by his own choice, Your Honor. Like,
he needs to unblock his father.
I mean, I can't
need to make sure that
force him to talk to somebody. Like, he's 15 years old.
I'm not forcing him to do anything except not to block his father from his phone.
He doesn't have that right to do that.
No, he doesn't.
It's his phone.
Does not.
It's his opinion, his voice. So you're telling me
he turns 18, he can call his own shots. Until then, he can't.
So he has no voice. He has no opinion.
What child has a right to a phone?
The child that does his chores and he earns it.
Well,
he pays for his own phone. That's his.
whatever.
I don't know why it's
simply,
whatever.
I'm just simply stating that he
If he doesn't
cannot
wanna-
block his father from communication through his phone.
You're ordering that he cannot do that.
I'm ordering that he cannot do that.
So
And that
you're
I'm
taking away
ordering
his
you to make
rights.
sure it doesn't happen.
You're taking away his rights.
He doesn't have a right.
He does have rights. He is a human.
Okay, we're not going to argue about this.
Well, I am arguing about it because my 15-year-old is not
Amanda,
just a
you are
nobody.
dangerously close to this court simply granting the relief that Jesse is asking for and just retaking custody. We didn't have these problems when he had these kids.
We did, though. He blocked all communication with me. I never spoke to my kids in a year and a half because of him.
Well, and I think
I called every single night.
your involvement with drugs had a lot to do with that.
Okay, Your Honor.
I mean,
I send my kids to him and let him molest my children too. And then what? What do we do from there? I have to wait until it happens to them before I can save them.
Proof that he's a threat in that manner to your children?
I have to wait until it happens to my children.
You're saying somebody else has made an accusation, which is being investigated. The investigation is not complete, and there's been no findings.
You don't know that. We don't know that because it's still an open investigation.
Do you have them?
Do I have what?
Do you have any proof? Is there any report? Is there any finding made by a social services agency or anything else that this is?
I mean, would you like his ex-wife's number so you can talk to his daughter, who he did this to? No, because you don't want to talk to the victim.
I'm dealing with the children in this case only.
Which are the siblings to that child.
Okay.
So just because it hasn't happened to my children yet, I have to send them until it happens to them?
At this time, the court will just simply order that the existing orders of parenting time be enforced and be followed.
Can they be supervised? Can we add that in until this investigation's over?
No.
So just send my kids to go get.
That's something that maybe you should have talked about with Jesse a long time ago, but apparently
there's no talking to Jesse.
Communicate.
He will not speak to me. I have tried communicating with him. I have tried texting him. I have tried talking to him in person. He will not communicate with me. He turns his head the other way and ignores me every time I try to speak to him.
I'm sure, Your Honor.
No, it's not.
You
can ask his
folks'
girlfriend.
Financial resources are, but what really needs to happen is that there needs to be some sort of family therapy here. There needs to be a therapeutic environment where the kids can sit down comfortably with a mental health professional, a trained professional.
They are all in
Need
therapy.
to be talked through.
They are all in therapy,
As a group.
and they have been talked. The therapist talks to them about their father.
I'm talking with their father involved in it.
I mean, if he would ask questions or if he would get involved, he could be, but he's not. He doesn't care to.
Jesse?
He'll say he does, but.
So the kids are in existing therapy at this time?
Yes, they have been.
With
South Central.
She won't even talk to me about their well-being. She won't talk to me about, I didn't even know if she was in gymnastics again.
She's not. Nobody said she was. Like, you just keep making things up and it's not true. I have text messages that show that you will not communicate with me. I have recordings of you not speaking to me when I'm trying to ask you about the children and their extra activities. You refuse.
The only thing that Amanda has tried to communicate with me was wanting money out of me, and that was it. And I told her I will not talk financial discussion with her because everybody knows that she's only after child support. That's why she's doing this.
That has nothing to do with child support. I asked you to pay for your daughter's cheerleading registration fee because I paid for everything else, and you refused to. You've refused to help me with anything with them possible. I've had them for 3 years now, and I've paid for every single thing possible, and I have asked you to help without going after child support for you, and you refuse to do anything for these children. If anything at all, you refuse.
how much per month, Amanda, is he supposed to be paying currently?
There is no child support order.
Okay.
Like, we have agreed to that he's supposed to pay for extracurricular activities and I think medical expenses or something if they didn't have insurance is what the divorce papers say. but he does not pay for anything. He has not given me or the kids $1 in over 3 years. I asked him to buy our child pants last winter, and he refused to, told me he wasn't going to spend money on clothes for them.
I never said that.
I could show you receipts and everything that I have paid for schooling, extracurricular activities. I have paid for every single thing without a single help from him, and he refuses to help.
All right. Since apparently both of you lack financial resources to be able, in this court's view, to pay for professional intervention, this court is inclined at this time to order a Butler County Court Services officer to do an investigation in this case and to make recommendations to the court.
Thank you, Your Honor.
I'm not altering any existing orders. I'm not letting you off the hook, Amanda, regarding your responsibilities to make these kids available and to have them at the exchange points when the court orders. I'm sure you'll be contacted by your court services officer. Now, I think I have Jesse's current address on. Correct, Jesse? Yes, okay. I need an address and phone number for you, Amanda.
The same one you sent the paper to. I've been here for 2 years. Yep.
Okay.
Lot 4.
Okay. Fair enough. And I need a phone number for you.
Same phone number that's on file. Been the same
What's
for
on
5.
file? I mean, and that's reflected by paperwork that you filed?
Yeah.
Hmm. All right, you'll be contacted by a court services officer here in due course. We'll consider those recommendations, taking into account what might be in that report, and we'll consider that regarding any future modification of orders. In the meantime, you two need to communicate. And Jesse, the right to talk to Amanda shouldn't result in arguments and name calling or anything else, but rather discussion, peaceful and non-harassing discussion regarding the interests of your kids. So unblocking, Amanda. And then don't misuse the right to be able to call, Jesse.
Yes, sir.
What's the best time for him to call, Amanda? What time of day?
I work at the high school in the lunchroom, so anytime there's no school, the kids are usually home. RJ usually is not. He goes and hangs out with his friends. But the 2 younger ones are home most of the time with me. So whenever school is out, we're home anytime.
Okay.
I don't work nights. I don't work weekends. I work total opposite.
Very well then. Jesse, anything further at this time?
Yeah, I would just like the police to be able to enforce parenting time rules. That's all I really want. I just want the ability to be able to see my children.
Okay, I understand. And the court essentially backs you on that, Jesse. I'm enforcing and maintaining the current orders in effect without change.
Okay. So the police aren't going to be able to make her stick
Well,
with it.
if you have a court order that sets forth parenting time and a parenting exchange point and time, and you're there, yeah, I would think law enforcement should enforce the order.
They've asked me for the paperwork every time.
Okay, and don't you have an existing parenting plan which sets forth those orders?
Yes, but I don't. It doesn't say that law enforcement has to enforce them.
Well, if you want to draft and submit such an order, the court will consider it.
I thought that's what I did. My bad.
Are you talking about your proposed parenting plan?
Yes.
Okay, well, I don't know that I'm going to go as broad with future orders as to what that says. There's all kinds of stuff in your proposed parenting plan order. I'm looking for something a little bit more narrowly tailored to what's in the existing order and that law enforcement is authorized to assist.
Okay, so I don't understand. Am I still not going to be able to see them, or?
Okay, I didn't say that. So
Oh.
You should be able to see your kids. That's what this is all about.
If I don't have orders that state that law enforcement is to enforce it, then they won't enforce it.
Okay, and I've already suggested that you submit an order setting forth your existing parenting time orders, as well as a provision that law enforcement is authorized to assist.
Okay.
You're the movement, and you've got the responsibility to draft your own orders. Okay?
All right.
All right. Again, you'll be contacted by a court services officer here in due course.
Yeah.
And I'll expect you to cooperate with that officer as they do their investigation.
Oh, yeah, I will.
Very well. There's nothing further at this time. The next matter will be in recess, and this meeting may be ended for all.
Fleazar, Aaron Michael Fleazar. 25T721893.
All right, I'm gonna let you go. The code is supposed to be really good. A lot of guys don't work it. So, all right. Aaron, come on out. Go out to the left, to the right, left, right. Gotcha. And then have a seat in that orange chair. We'll wait for your case to get called. Sure. Here, wait for this on you too. Here, Scott, 7 seconds.
You could stand up, sir, unless you're
Go
disabled.
ahead, stand up. Oh, sure. Sorry, Judge, I told him to have a seat. They're gonna stand on that red X.
That's all right.
These are
Your name?
contact. Step back for me a little bit so you're not so close. Go ahead, state your name.
Aaron Fletcher.
All right, and Mr. Westmoreland, your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Fletcher.
All right, and Sergeant, your name?
Detective Sergeant Driscoll, Trent Police.
It looks like Judge Mullins, I believe I was absent that day, as I recall it. I don't know if you remember, Lisa, but I was absent, and Judge Mullen, my place, I think,
Yeah, you're correct.
set a
Judge.
5,000, 10% bond in order to not to have any contact with Adam Grote, not to enter or go near 3750 Brookshire and Trenton, no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs, no firearms, no dangerous weapons, and defendant was required to obtain a tether within 24 hours of release from custody. So, hang on one second. See, I'm gonna talk to you about fucking cheap marijuana. Well, I've been meaning to talk to you about that for 2 weeks. Okay, so then I got a signing on record on the, he was in Chattanooga, failed to acquire the GPS. Court found by preponderance of the evidence that the defendant violated his bond condition by failing to acquire a GPS. I revoked the release, forfeited a bond, and ordered $50,000 cash or surety. So, what are we gonna do on this one, Mr. Westmoreland? I mean, I could take, you can just argue bond, or if you want to have a bond hearing as to whether or not he failed to acquire his GPS tether as ordered by Judge Mullins, that's fine too. What is your preference here?
Your Honor, I would just ask that this matter be reset, and I will argue bond on behalf of Mr. Fletcher.
Sure, go ahead.
Your Honor, I would like you to know that Mr. Fletcher is currently homeless, and he is currently unemployed, so he has no means of paying for any sort of tether. He's not currently on probation or parole. I don't believe he has any prior criminal history. At least he indicated to me he did not. He has no other pending matters out of any other court. And after speaking with Mr. Fletcher at length this morning, he did assure me he would be appearing at all future court dates, and he does understand the importance of doing so. I believe last time he felt that he was threatened and he could not appear. But moving forward,
Wait a minute, say that again.
Mr. Fletcher indicated to me that he felt that he was in grave danger and he could not appear.
Danger by who? From who?
Your Honor, I'm not exactly sure at this time, but Mr. Fletcher did assure me he will appear and he understands the importance of doing so.
Did he make any police reports?
Not to my knowledge.
He's I don't know if we have if Judge Mullins ever signed the complaint. Wonder if we can send that. Can you send that over to her? Oh, wait a minute. She signed the warrant. Oh, she did sign the complaint. Why did you leave without getting a GPS tether, sir?
I feel that my life is in danger, and that's what set this whole thing in motion.
Your life is in danger.
I have no interest in defrauding Growit, Adam, or
I want you to talk about
else.
hang on. I want you, hang on. I want you to talk about the case. You should not be talking about the case. Okay. I don't know why you're telling me your life was in danger. Did you tell Judge Mullins your life was in danger when she was setting the bond?
Yes, I've told everybody.
He tell you this, detective?
He did not, Judge. Me and Mr. Fletcher has not had any real conversations to that effect.
You told Judge Mullins at the time of the arraignment that you felt your life was in danger? I don't want to put words in your mouth.
A tether tracks to exactly where I am.
Say that again?
The tether would track to exactly where I am.
We know that.
I am moving. I was moving around to try to avoid. I have to give you the whole story, or you don't get the whole picture. Yes, my life is in danger, absolutely 100%, and I have documentation that proves it inside and out. That's why I'm more than happy to come to trial. I'm more than happy to speak to a judge and a real lawyer and everything else. I have no problem with that.
I'm a judge, and he's a real lawyer, and he's a real detective. Okay. Listen, Mr. Fleezer. You were ordered to get a GPS tether. I know not what you're talking about, sir. I do not know what you're talking about. Have you ever treated for mental illness, sir?
No, sir.
Do you work?
I haven't worked in a long time, sir.
How long?
I don't have a problem working. I'm not a bum. I have skills. I'm more than capable.
You were a bum. How long since you've worked?
Since. So you mean since I've been paid for work? Probably about April 2008, maybe.
Where do you live now?
I'm denied employment. My phone calls are intercepted.
Where do you live now?
Visits to law offices are intercepted.
Listen,
just telling you, I want to be honest with you.
Well, I want you to be honest with me too. Where do you live now?
I go from hotel to hotel to hotel to outmaneuver whatever the heck it is that's coming after me. I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit. The code is basically how they get rid of people they don't care for.
The federal government you're talking about?
Correct.
Oh boy.
It's none of it's legal by any means, but it's very damning to say the least. So I kind of keep that to myself, but it doesn't allow me to survive. Like I said, I'm not choosing to have my calls intercepted. I'm not choosing to have my automobile sabotaged, my family's home sabotaged. The list goes on, and that's why I know you don't want to go into detail. But I have to be honest with you. Yes, my life is in danger. That is the whole reason why I'm here. Why I took the mail that I took.
All right, you should not be saying that. You should not be saying that. You should not be saying that, sir. You just should not be saying that. I'm trying to caution you not. Listen to me, please listen.
Go ahead.
You shouldn't be making admissions. You should not be making statements that are against your interest. I'm concerned here. I don't know what to tell you. I'm going to set $2,000 cash or surety. $2,000 cash or surety that you're going to have to post. And this time, I'm going to change the bond conditions ever so slightly. You're not to have any contact with Adam Grote. You're not to have any contact with prosecution witnesses. You're not to enter or go near 3750 Brookshire in the city of Trenton. You're not to possess firearms. You're not to possess dangerous weapons. You're not to purchase, possess, or consume alcohol or illegal drugs. You're not to be released until fitted with a GPS tether. You're not to be released until fitted with a GPS tether. So even if you post the bond, you're not going to be released until they can fit you with a GPS tether. Also, I'm going to order you to attend a psychological evaluation and treatment. You can call the probation department. So if they recommend probation's going to give you some names as to where you can go. You're to attend a psychological evaluation and treatment if recommended. So those are the bond conditions. I'm adding a couple that Judge Mullins did not have. And you have never heard anything about this at all, Sergeant?
I have not, Judge. I know there was some conversation about his monies being funneled out of his bank account, but we didn't get into a conversation involving people coming after him.
All right. So, Mr. Fleaser, I'm sorry. I'm going to give you a new date. It's going to be, what, January the 6th, is it? Lisa?
January 6th at 10 o'clock.
January the 6th of 2026 at 10 a.m. I hope you didn't pre-try that with those guys. I told them we needed an Arabic interpreter.
His son spoke for him.
Yeah, I can't do that. It's a criminal case. I just can't do it.
I understand.
I just can't do it. I tried to tell them that. I mean, it's a criminal case. I'm supposed to get an interpreter. So I can't. I'm sorry. I just can't do it. That's the way it is, Mr. Fleazar. I'm sorry. So I want you to get a psychological evaluation and treatment. You can post $2,000 and you're not going to be released until fitted with a GPS tether. Okay? Do you understand, sir?
Yes, but I don't have $2,000.
I'm sorry. You should have shown up. You should have shown up. You didn't get your tether and you left the state without. Sir,
I was told that the actual judge wouldn't be there.
What's that?
I was told the actual judge wouldn't be there, that somebody would be sitting in who doesn't actually normally be there. Plus, the lady that I spoke to, that was the judge, had the same name as you, sir.
No, she did not have the same name as me. It was Judge Mullins.
It did on the screen when I talked to her, because I was wondering why it was McNally, because that was the paperwork posted on her house.
Okay, listen. You were in front of Judge Mullins. You were in front of Judge Mullins. She told you to get a GPS tether. You didn't. I'm not going to argue with you. You're going to have to post $2,000 and they'll give you a GPS tether. If you post the bond and you get the tether and you are released, I want you to get a psychological evaluation and treatment, okay? They don't need to come in here. I already told them to go down the home.
I know, Judge, you can speak English.
No, Mr. Muhammad, come on. He told me he could just, yes.
Thank you, Judge.
All right, thank you.
told me he
So
could
that-
speak a little bit, and then he wanted to have his son interpret for him. And I can't do that on a criminal case. Call the state court administrator's office. They're going to tell you that. I mean, I can bend it on a civil infraction just a little bit, but
I understand.
it's not my call. I just do what everybody tells me to do here.
I understand. It's just we discussed this whole case in England. So that's why I was.
Why did he tell me he just could do a little bit? Why was he, when I was conferring with him, asking his son? I can't do it. I'm sorry. Tyler Joseph Bensick, 25W729306. Counsel, I'm going to ask you to have a seat in the back there. Counsel on the defense, would you do that, please? Just in the front row there. Come on up here, Mr. Callahan and Mr. Bensick. I'm going to ask you to have your seats over here at the fence table. And then I want Mr. Hipsley up here, and I want Ms. Alloway up here. Where's Ms. Alloway? Yeah, you could, well, you guys can sit there. I want to talk to people here. You can just sit. Where's Ms. Alloway?
Oh, you're over here with them. Yeah, I understand.
And sir, you can have a seat in the front row. You, Mr. Hipsley, is it?
Yes, sir.
Have a seat in the front row. That's where the prosecutor's going to sit. You're not the prosecutor.
Sit back there.
One row.
Over here.
Oh, she's there.
Sorry. So we have a bond violation hearing. Ms. Alloway, come on up here, please, and tell me your name.
On behalf of the simple police 6528.
I hope I'm pronouncing that correctly every time, am I?
Yeah, you.
All right, so, Mr. Callahan, your name?
I'm Callahan, 830561 on behalf of the defendant.
Mr. Bensick, your name?
Tyler Bensick.
Mr. Hipsley, your name?
Kevin Hipsley.
I want you to read some of those texts to me that you brought up last time that caused me to make these gentlemen come in here for a bond violation hearing.
Just gotta write the password. Okay, so, I spoke to the plaintiffs here, I think on this matter, she advised that, you know, you haven't hit free.
Nice them out for me.
A man named Kevin Hipsley had been messaging her on Facebook as recently as the last Monday, which would be December 15th. And so some of those texts include her saying, leave me alone. He says, you leave me alone, you dirty fucking stinky ass whore. She said, you texted me. And then he said, dirty stinky whore. It's okay though. I warned everyone about you and who you are. Folks, give me 1 second. We lost it here. I'm sorry, Judge. I promise once it's open, I'm going to just leave it. Okay.
Fine, you take your time.
I think the luck cause dumb bitch, don't you have warrants? This is gonna be easy for us, not for you, anything. Hi, baby ass bitch, STFU and GTFO. And then he also said, I don't know, there was something before this, but he said, no, you are for making false accusations against Tyler, you've done whore.
Please, I don't even want to hear this anymore. Lisa, is Jade?
We did speak in chambers, based off of the text that he made, it appears to be on behalf of Tyler Bensick. These were not texts made by Tyler Bensick, but the no contact order does state that third party contact that is intended to intimidate or harass the complainant is considered a violation. This complainant is very afraid of both of these people. I don't know if they are friends or hanging out, but regardless, she doesn't deserve for this to happen.
Lisa, is January 6th, 1 o'clock a good day for the exam, or did I set another one at 1?
We have a couple at 1 o'clock.
We'll
Let me
make this,
double check.
if we do, I'm going to make this one at 2. Come on up here, Mr. Hipsley, up to the podium here.
You have one at 2 and one at 2:30.
But none at 1?
Oh yeah, you have several at 1.
Right here. On the 6th, I do?
On the
Okay,
6th.
well, we're gonna make this 1 o'clock too then.
Okay.
Your name? Kevin Hipsley. Your name again?
Tyler Bensick.
Mr. Bensick. I don't want to know if he's a friend of yours or not. I would assume he is, but I'm not gonna make assumptions. If he keeps talking to this lady like this, you're gonna end up with a really high bond in jail for a long time. I don't know who you are thinking you could text and threaten people like that and call them names like that, Mr. Hipsley. Do you understand what I'm telling you, son?
Yes, Your Honor.
You pull this nonsense again, you're gonna have a long way to hoe with me. I'm telling you. I'm so flabbergasted, I think I can actually maintain my cool over this one. Because it's so derogatory, so mean, like, you must be emperor of at least the world to talk to somebody like that. I'm telling you, you're going to have a big problem. You come anywhere close to even dreaming about calling or texting or emailing or phoning her, going by her house, going to her place of employment, driving around the block in front of her house, her residence, or if she's at Myers or any other place. Do you understand what I'm telling you?
Yes, Your Honor.
This is a courthouse. We show respect for the process. Do you understand?
Yes, Your Honor.
Mr. Bensick, I'm telling you, I don't want you to say a word. If I knew he was acting on your behalf, you'd be sitting in jail till the cows come home. Do you understand what I'm saying?
Yes, sir.
No more. January 6th, 1 o'clock. I expect there to be no more contact. Thank you, Mr. Callahan. Thank you, Ms. Alloway. Merry Christmas, everybody. Happy holidays.
We're here on a number of cases involving Melinda K. Fowler. That's you. And it's going to take me a minute to recite all these. We kind of cleared the deck. Abby Stoll from the prosecutor's office has been shepherding these cases. Also present is Mr. Joshua Robert, the chief assistant. He's stuck with me for a bit longer. Your lawyer is Ross Truckee, and to his credit, he's been sitting here for 2.5 hours waiting to call this case. He and Miss Stoll and prosecutor George from the city of Three Rivers has been working on all these cases. And there's a bunch of them. And you've been in jail for a while, and we have some correspondence from the jail nurse regarding your circumstance. First charge is file 251812FD as a charge of operating while intoxicated. Third offense is a felony offense. That's a felony. Drunk driving, third offense, punishable by up to 5 years imprisonment. Mr. Truckee, what are we going to do with the drinking driving case?
So we would be entering a plea to OWI second offense today to resolve that.
OWI second is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Carries 6 points on your driving record and it requires that your license be suspended. I'm aware that you were in a treatment program and you're in the middle of the treatment program and you'd like to get back to your treatment program. So Mr. Truckee is going to discuss a bond that would let you to get out of jail and get back to your treatment. You understand?
Yes, sir. Thank you.
But I put you in jail because you don't go to treatment to duck going to court. These matters needed to be addressed. So this is a felony. It allegedly occurred on September 4th. And you were not doing well all through this year. Next case is a retail fraud third degree from June 28th of 2024. That is file number 241175. We've got a bunch of retail frauds from 2024 and some more from 2025. Ms. Stoll or Mr. Truckee, what are we going to do with that one?
There has been offered to plead to the most recent retail fraud and dismiss the balance of retail fraud charges.
All right, so 241175 would be dismissed. Is that correct, Ms. Stoll?
That's correct.
Uh, 241826 retail fraud third, also dismissed. Two 251408 retail fraud third dismissed. That's 25, excuse me, that was from June of this year. 251408 SM dismiss.
No, that would be the file, please.
No, she has a subsequent one.
There's a city one that's subsequent, and that'll be
Oh,
dismissed.
all
as
right,
part of
that'll
the
be
deal.
dismissed. So she's gonna plead in 1408. 1408. Plea RF third. I have $50 of bond. All right, the city ordinance retail fraud is 251817. That's from August. And then the defendant is going to plead to the city open intox charge.
That's correct.
Let's start with that one. Ms. Fowler, you're charged in file number 241784 with having open intoxicants in a motor vehicle. Let me find that case. One 794. You got a ticket on August 29th at US 131 in Broadway. We seem to get a lot of cases right there where it's alleged you had open intoxicants in a motor vehicle. As I said, that's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100 under 3 years ordinance. Do you understand the charge?
Yes, sir.
Other than this plea agreement, did anybody promise you anything to get you to plead to that charge?
No, sir.
Now, these rights apply both to this charge and the drinking driving charge. I'm going to see you after the first of the year on the drinking driving. We'll talk about that one in a minute. But in both cases, by entering a plea, you give up your right to have a trial. There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee, his credit, has taken on all of these cases and has worked on resolving everything. You could also hire an attorney of your own choosing if you wished. if you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, a judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Understand?
Yes, sir.
All right, what did you have in the car that day at Broadway and 131?
I had one of those flavored beers in my middle console of my car that was half drank from the night before.
What flavor was it?
It was the grape one. I don't even know.
Oh, you mean like a wine cooler?
Yeah, one of the flavored, they come in a can.
I mean, seltzers.
Yeah.
All right. All right, let's see. Been in custody for 12 days. Days credit, 12 days, leaving 0 days to serve. No waive the fine and costs. We'll pick that up on the drinking driving charge, which is a different day. That was the 30th. You got arrested for operating while intoxicated a few days later on September 4th. You do have 2 priors. One is old and one is not so old. Let's take a look at these. One 1812. All right, started out as a ticket. You were pulled over at East Main Street in Centerville. You also had open intox that day. They pulled you over at 5 o'clock at night at DHS or something. Where did you get pulled over?
At the DHS parking lot, right in front.
All right. Had you been there
Yeah,
seeking services?
I had an appointment with them.
And had you been drinking before that?
I had.
And I'm trying to find any sort of facts. Then they ran your criminal history and realized that you had other charges. And then they charged you as a third offense. You were here on that in September, and you had gone to Gilmore, and then you were going somewhere else, and then you sort of went off the grid. But what were you drinking?
I was just drinking beer.
Did they give you a breath test?
Yeah,
Do you remember what the result was?
I don't recall.
Can Abby
It
or
was an
Mr.
intoxilizer test. It was a 0.21, 0.19 on the blows.
At 5, earlier that day, you were at DHS and you were almost 2.5 times the legal limit. You were quite drunk when you went there, which is obviously red flags. You were in rough shape for the last year. And we need to try to figure out what to do here. All right, you spent one day, and you bonded out, and now 12 days. And then you went sort of off the grid while you were in treatment. And thank you to Mr. Truckee, agreed to take all these. So we got correspondence from the jail nurse. She tells us that you've got some medical issues that need to get addressed and you wish to get back into your treatment program. And you told me at the time I put you in jail that you were in the program. You are about 4 weeks left at a 90-day inpatient program. Are they willing to take you back into that program?
Yeah, they contacted the nurse and let me know that I had the bed still available.
And what program is it?
It's Our Hope in Grand Rapids. It's the Walker Street location.
All right. I suppose that might be a good cause of action. A course of action is to get you back into treatment pending further disposition in this case. I don't know if you're sobriety court material, if it's just a regular probation or just a jail sentence, but you were bound to hurt somebody or yourself. And this arrest was actually a blessing that somebody intervened before you killed yourself. All right, I'm going to amend the bond in the drinking driving case. It's currently $10,000 cash or surety. To a $1,000 PR bond with condition that defendant enter Our Hope Recovery in Grand Rapids. And not leave the program without completion. The other conditions are no drugs and no alcohol remain in effect. You also got some medical issues, which I think they may help you address. I'm going to set the sentence out a bit.
January 16th. I'm not sure. Days that I missed.
Ross, are you available on February the 16th at 11?
It's President's Day.
Oh, it is.
But yes, I am.
How about February the 9th?
Yes.
February 16th is a good day to spend at Louis' backyard in Key West. Maybe I'll go there. Set for sentencing, February 9, 2026 at 11 a.m. We're going to have to stay in contact with you through your treatment program. If they want to keep you longer, that date could be moved, but I'm trying to time it when I think you're about going to be done with the program. Do you have a plan for where you're going to go when you complete treatment?
I plan on going to one of the sober livings in Kalamazoo. There's several I've got applications to right now.
All right. Well, you got a clear head. You've been in jail now for 18 days and you're alcohol free and making sense. So we'll use that date, February 9th at 11. I'm going to give you a handwritten notice, which ain't the best. You'll get further notice, but
Try to call my
I guess you called me.
if nobody answers, the extension is 270 for the floor that I was on.
all right, that takes care of the alcohol cases. Do we have a retail fraud case we needed to do also?
Yes, city's taken care of, the OWI is taken care of, and now it's just 251408 SM.
All right. I can put restitution for all the retail frauds in the drinking driving case if need be. In file 251408, you're charged with a retail fraud. You were kind of on a roll there. Let's take a look at this one. They kind of blend in together. 1408. That's from June. That is alleged that you were at the Shell gas station in Three Rivers. That doesn't make sense. West Pigeon Shell. I think they mean West Michigan Shell. That you were in there and you stole something. Most of these were beer. In 1408, I'm looking for an affidavit or something, but I can't find one. Abigail or Mr. Robert, can you tell me what it is that she took?
It looks like she took
2 natural ice beers.
That's what most of these were. Did you go into the Shell station on West Michigan and steal some beers?
Yes, sir.
All right. I always wondered, sometimes people would be stealing liquor, and they would steal pop-off vodka. And I was like, well, if we're gonna steal it anyway, why not steal Kettle One or something? But same thing with beer. This is cheap beer, but it has a high alcohol content, and people drink it because it's inexpensive and it has more alcohol in it than some. All right, let's see what we got here. Same thing. You made it. You got arrested on the 2nd, posted bond on the 2nd. So you have 19 days credit in that one. Fine is $0. $75 crime victims' rights fee, $50 state minimum fee, and $25 restitution to Shell. That's $175. You posted $50 of bond. So there's $125. We'll make that due by payment plan with OUIL 2nd. But we'll be able to use part of that bond to pay $25 restitution to the store. It's more than the beer cost, but it's an aggravation. All right, Ms. Fowler, that takes care of your open intox, one of the retail frauds. The other retail frauds are dismissed. The open intox, I gave you 20 days jail credit. The OUIL will address February the 9th. The other cases are dismissed. All right.
Thank you. Right. Don't step foot out of that lobby.
Yeah, I won't. So I was
Still, our hope is there, okay?
Thanks, Ross.
Take care, Melinda.
Thank you, Abigail.
Thank you, Abby.
Thank you, Ross, and thank you for your patience. That took your whole morning, but we
I had
did.
some business upstairs too.
All right. Mr. Cap, good afternoon or good morning. This is file 252477, People versus John William Cap. Mr. Cap, you're there in custody at the St. Joseph County Jail. Your attorney, Rhonda Ives, is here with me at the courthouse. Your parents are also here, as they always are, and they're here in the gallery watching the proceeding. Mr. Aubert, what is the current plea offer?
So I just talked to the attorney, Ms. Ives. She hasn't had a chance to talk to her client about it yet. The offer would be for him to plead to impaired driving, second offense, and attempt to RNO.
Can I go to the breakout room and talk to my?
Yes, I'm going to let you talk privately with your lawyer. You mentioned one report is back and one is not. Which lab report is back?
So the alcohol lab is back. It always takes a little longer for the drug lab to get back.
And what does the alcohol one show?
0.05.
All right, you're charged with operating while intoxicated, third offense, which is a felony. It's punishable by up to 5 years imprisonment. I think you're also charged as habitual.
Yes, he's a fourth habitual.
As a fourth habitual, which would make this theoretically punishable by up to 20 years imprisonment. You're also charged with resisting, obstructing a police officer as a fourth habitual, which would make that, I believe, I couldn't figure out whether it's a 5-year or 15-year. The prosecutor has agreed to dismiss all the felony charges for a plea to impaired driving second offense. Impaired driving second offense is a misdemeanor punishable by up to a year in jail and a fine of up to, I believe, $1,000. Carries 4 points on your driving record. Attempted resisting, obstructing is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. Again, that offer was just relayed to your lawyer. She hasn't had a chance to talk to you. I'm going to put you guys in a breakout room and let you discuss that privately while we wait.
Can I clarify with Prosecutor Robert on one item?
Yes.
Prosecutor Robert, the theory of the OWI second would actually be operating under the influence of a combination of drugs and alcohol?
Yes.
All right, thank you.
We're going to return to file 252477, P versus John William Capp. Mr. Capp is connected to us via Zoom from the jail. Rhonda Ives, his lawyer, is here with us at the courthouse. Also present is Chief Assistant Prosecuting Attorney Joshua Robert. Prosecution had offered to dismiss the felony charge of operating intoxicated third offense and attempting to resist or obstruct a police officer for a plea to impaired second by no contest and attempting to resist or obstruct a police officer. The impairment would be a combination of alcohol and any other substance, including marijuana, methamphetamine, or prescription medication. Could be a sufficient factual basis for the impaired charge. Mr. Capp, you've had an opportunity to discuss that with your lawyer, Ms. Ives. Are you going to plead to that charge?
Your Honor, Mr. Capp is willing to plead no contest to the impaired driving second offense and to the attempted resisting and obstructing, with the condition that the other files or the other charges be dismissed.
These felony charges?
Correct.
All
Yeah.
right.
And he also was requesting screening for sobriety court, which.
And we can do that. There's some impediments to that. One, you have 2 more driving suspended cases pending pretrial on January 2nd. You also have a felony charge of possession of methamphetamine and felon in possession of a firearm, some other charges pending in circuit court, and filed 2425340. You also have $3,616.70 of unpaid fines and costs going back to 2022. A lot of that is restitution in an old larceny case of $2,800. So I'll screen you for sobriety court. You certainly could probably benefit from it. But if you got pending felony cases, that might make you ineligible. But we can always see where we go. So, Mr. Capp, are you going to plead no contest to impaired driving second offense and to attempting to resist or obstruct a police officer?
Yes, Your Honor.
Other than the plea agreement that's been discussed here, which does not encompass your felony case, it does not encompass your 2 other driving suspendeds and an open intox, but in the parameters of this incident from December 2nd, the felony charges will be dismissed and you will enter a no contest plea to those two misdemeanor charges. Now, you probably know this, but let me explain it once again. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter.
Yes.
And I'll get the factual basis from the police report and perhaps laboratory reports and other documents rather than from you. A no contest plea can be due to lack of memory. It could also be the fact that this conviction would be a violation of your bond in the felony 2425340. There would be sufficient reason for no contest plea. And you and I have discussed this before, but let's go through it here. To understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury. Do you understand?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Ives is here and is working on this case. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor. I'd like to proceed and get behind me.
Say that again, I didn't get it.
I would like to proceed and get this behind me.
All right, that's probably a good plan. All right, so this started out as a over-the-counter felony complaint. This incident occurred in the city of Three Rivers on December 2nd. And you and I have discussed this before, that it's like swimming in an aquarium and you keep driving in Three Rivers and you know they got it out for you. And you know every time you drive, they're going to pull you over again, but you keep doing it. And I don't really understand. But according to the bond information sheet, it was about 3 o'clock in the morning near your house, Pearl Street and 3rd Street, a red VW Bug on Broadway near South Main. You went up over the curb and then got out of a snowbank, turned left on 5th Street from Broadway. The vehicle turned short and went into oncoming traffic on 5th Street. I'm not sure how much traffic there is at 3 a.m. on 5th Street. The vehicle then turned right onto Pearl Street, which dead ends. You can't get across Pearl Street. It's blocked off. The vehicle then went into a private drive and the driver, John Capp, entered the vehicle. He had a strong odor of intoxicants and his speech was slurred. He refused to do sobriety exams or the PBT. Where's the R&O part in here, Mr. O'Bear?
Your Honor, I've got a portion of the police report regarding their conversation and initial communication, as well as a short video clip, if that would help the court.
The police report probably will be sufficient. Let's take a look. This is no contest. Now, Mr. O'Bear, you indicated the lab report has come back as a 0.05 for alcohol.
Yes, the initial lab report shows 0.05 for alcohol. Additional testing was going to be completed for controlled substances.
All right, and we'll have that before we actually do the screening.
Your Honor, if I may approach.
Yes. He got out of the vehicle and attempted to walk away. They asked him to stop. He was very slow to follow commands and seemed to be confused. He showed indications he was attempting to flee or was thinking about it. Refused to provide his name or identification. And he was detained. That's sufficient for attempted R&O, pretty much attempted. The I only have to find the principal charge, but the complaint shows a prior in 2017 in Kalamazoo District Court and a third offense again on January 3rd, 2018 in Kalamazoo County District Court. So we need to set this matter for screening and sentencing. Facts from bond info report and police report. As I said, Mr. Cap, I don't understand this whole dynamic where you just keep driving because I've said that like you just given up. But it's 3 o'clock in the morning. I don't know whose house it was on Pearl Street. There's only a few houses on that block, but it dead ends. Let's find a date that works for Miss Ives. She's got some vacations planned.
And I think
for the
Mr.
first
Cap
quarter
also,
of next year.
yeah, Mr. Cap also has a jury trial scheduled, I believe, in January. I don't know the exact date. Maybe the 6th or the 13th. Do you know, Mr. Cap?
Oh, it's the 27th.
Oh, I'm sorry, the 27th.
All right, well, let's set this out a bit. I gotta get back in my district court case. I was looking up his circuit court case. Now, Rhonda, you're gone from January, February, and March.
I'd like to be.
I tried to sell February the 16th to Ross, but he told me it was President's Day and he didn't want to be here that day. So
I can tell you I have nothing going on that day, and I
well,
would be
neither
really
did
easy
he.
for me
How
to be
about
here.
February 9th?
Sounds like a date, Your Honor.
All right, February 9th at 11. That way, your circuit case will either be resolved with a plea, trial, acquittal, or dismissal. Anyway, it should be over one way or the other.
I believe he also
Before-
has felonies pending in Muskegon County
Uh,
for home invasion, possession of narcotics, driving suspended, larceny in the building.
Everything was dismissed except the only thing going to trial is the possession of some Tylenol, I guess.
All right, well, I won't worry myself with that. We're gonna deal with this.
Okay.
All right, that resolves this. We don't need a preliminary examination. We're gonna have a screening. We'll have the further lab report back by then, see what else is in there, if anything. You've had, see how long you've been in jail. "21 days that you've been in custody. Of clear-headed thinking.
Yes.
You'll get credit for all the time served when we do the sentencing on February the 9th. All right, Mr. Cap.
Thank you.
I'm not sure where this is going. There's a lot going on. And see you in February.
Sounds good. Thank you.
All right, that completes our morning. I think it completes our day. So I'm gonna stop the live stream, stop the record, and go look at those PPOs. Merry Christmas.
And a very early Merry Christmas to all of my friends who may not be around for the next couple of days because family matters. And ladies and gentlemen, I encourage you, if you have the opportunity, spend as much time as you can with your loved ones during this Christmas season. But just to let you know, if you're looking for your court family, we'll be here. Same wolf time, same wolf channel. Christmas Eve night, there will be court to watch. I haven't had a chance to put out nearly everything I have access to, so I'm gonna share a little bit extra. And if you're interested, Mama's given her permission, and ladies and gentlemen, we're going live early on Christmas Day at 7 p.m. Central Time. That's 8 p.m. Eastern Time. We're going live a whole hour early for a Christmas court special. Ladies and gentlemen, I want you to stay tuned if you want to watch more court, because we're headed over to Sovereign Citizens Encountered right now, and they have a court case kicking. And ladies and gentlemen, it's a good one. But for now, I am your Lone Wolf Usul. I'm your curator for these here videos. I am your humble servant for the court gallery, and I thank you very much for your patronage. Oh, and by the way, I want to give a special shout out to all of my friends who donated tonight. Great Granny Zach. What does this say? Steve's Model Builds? Thank you so very much, Steve's Model Builds. I can't say it. I just can't do it. Mimsy, thank you so very much, all for your contributions. Your humble wolf does appreciate you. And ladies and gentlemen, thank you so very much for hanging out with me tonight, and I will see you tomorrow. Y'all have a great evening. I am your Lone Wolf, and I am out. Okay. That was a premature ending, but to Hutch, ladies and gentlemen, tell Hutch I said hello. Sovereign Citizens Encounters and Lone Wolf's Court Gallery. Y'all have a great evening. Good night, ladies and gentlemen.